Might as well. I was about to call 911, but you're sitting right here.
You don't come anyway. I have to. I want to.
No, I don't want. That's why I got people. I got people. I got people for that, and she loves that too. She told me today. She's like, oh, he calls. He's so nice and polite. And I go, Anthony, get up.
Leonard, did we get a new liaison?
How you guys doing?
No.
No, he's just visiting.
Oh, thank you very much.
You're welcome.
Huh?
The supervisor may attend as well.
No, I'm not.
Yeah.
Hi, everybody.
Hello.
Can I help out here?
Hey, Trouble. Hey, step right up. You want
No. And if they did, they can't put it in the front.
Nope, not for you, Mark. Oh, is there an agenda? We can go over there.
You're welcome. Oh.
Yeah, but it's going to be a conservation. So yeah, it'll be 166.
So what was the number?
166. Only going to use one portion. The rest of it would be. There wasn't.
Oh, Paul, I put the decommissioning agreement in Dave's hands today for Salix. And I think there's only one more thing we need for the conditions from them. Because I think we did, the only thing I think was left was them starting the NOI. The NOI. That's the only thing I think was left hanging out there. I'll check it again, but I think that's the last condition for them. So send along, and it'll be and I changed the date because the date shows when we started the discussion. I changed it to the 13th. They haven't signed it yet. I leave it to 13, and then Dave can sign it next day and give it back to them, and they can do Typically,
It never made it.
we don't allow people to sign,
Never made it.
supervisor to sign, so
It
they
shot
sign
down,
first.
shot down as information.
Maybe I'll reach out to them and have them sign copy, fill it. Yep. That's fine.
Yeah, let me get to the,
Wherever Lenny. was,
Clean version?
he was Very
the
involved.
administrative, clean that up.
And,
It was-
I'll put the, to be added item
Never got those.
at the back, site plan, aerial view, all the stuff we got during site plan, I'll put that in when I submit to the town board.
Okay.
All right?
First one. It's been a while.
All of it, Sarah, I need you to remind me to do. You'll remind me to do all that.
I'll try to.
Yeah.
Thank you, Sarah. Sarah keeps us all straight, you know.
Thank God.
And hopefully I'll see you next week.
Yes, sir.
Is it enough to make a map yet with any dimensions?
I have nothing new from
People
Christina.
have no idea, aside from their words, how big anything.
Nope.
Thank you.
Just that four-story addition that it's gonna put on?
Yeah. Right into my future bedroom.
Yeah, exactly. Spotlight.
Dave, when we get rolling, you're gonna, I didn't bring this stuff with me, you're gonna put the maps up for the Pino's and all, you can put those on the board.
Moi,
Yeah.
I can.
You're right.
If you'd like, I can do all sorts of things. I'm crazy that way.
I'm telling you.
Yep.
There it is.
Let's do it to him.
Thank you. Thank you. Anybody talk to Paulie? You know, if he comes.
I've not heard.
Oh, yeah, come on.
Is this me? It is. You are. We haven't started the meeting yet.
All right, I'd like to call to order the January 22 zoning board of appeals, town of Lloyd meeting. Please stand for the pledge, please. Pledge allegiance
To the flag, United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, exit search back room on either side. Please turn your cell phones to vibrate, please. All right. 10 public hearings, AEC Ulster, Falcon Ridge, 301 Upper North Road, and 357 Upper North Road, SBL 80.3-1, -18.110, and 80-3-1-31. Applicant is seeking to appeal the determination of the town code enforcement officer about the treatment plant and a portion of the road being in light industrial zones that are intended to serve single-family residences. All right, so as we were stated previously, the treatment plant is completely off the table. I want to make everybody very aware of that. There's no treatment plant. We're only looking at the access roads or the roads. All right, so before we get going with the resolution, is there any member of the public that wish to be heard on ADC Ulster? All right. Entertain a motion to close the public hearing. Russ? Bill? All in favor? Aye. Carried. Okay. I'm going to turn it over to our counsel, Paul Van Cott, to go over what we've collectively come up with.
Thank you, Mr. Chair. You'll recall at our last meeting, at the end of the meeting, the board basically did a straw poll, just suggesting that they would like to uphold the determination of the zoning officer with respect to this project. And following up on that, we were tasked with some additional homework in terms of looking at some of the factual, unique facts that are involved in this project and being able to bring that back to the board so that we could share that with you tonight. And essentially what we found, as you all will recall, what we have here is a parcel that is effectively split into two zones, light industrial and then R1, which residential 1 acre. And what is proposed is a residential access road through the light industrial portion of the property to be able to access the residential lands for purposes of a subdivision that's proposed. What we found when we went back to the zoning map is that there are really maybe 2 or 3 other parcels that are similarly affected. You know, where the parcel itself is split into the light industrial zone and the residential zone. We also found that this parcel is extremely unique. It's unique among any of the other parcels that are similarly affected, because you basically have a 36-acre portion of the land which is in light industrial, and then the bulk of the land is 483 acres about, which is in the residential zoning district. And the effect of the prohibition of a residential road through the light industrial lands would essentially deny anyone from building a residential development on those 483 acres. it would be the same for the other parcel or two that are affected. Where they would not be able to build a driveway across the light industrial lands, even to build a single family dwelling. So, you know, the impact of this is significant, and the property that we're dealing with is very unique. What we also found, and where this is you know, even more unique, is that this parcel, if access is denied through the light industrial lands, this parcel is landlocked. And there is no other way that access can be obtained to the residential lands for residential development. So, you know, again, you know, the land was zoned R1 for residential development by the town, and the property owner can't get there. And then the other unique factor here is that, and this has been discussed by the board previously, the impact of driveway for residential purposes across the light industrial lands to gain access to the bulk of the property, which is residential. The impact on that light industrial lands of that driveway is minimal to none. You know, it's a far different situation than if the zoning districts were reversed. And what we were talking about is an applicant who wants to gain access to the light industrial land so he can develop a gravel pit and wants to drive the gravel trucks through the residential zone. So again, you know, these are all, you know, unique factors that really makes the parcel that is in front of the board based on this interpretation probably singular in the town. So around these unique facts, we also did some additional legal research to really assess the authority of the Zoning Board of Appeals to modify an interpretation of the zoning officer based on what is good law. You know, the 2012 case that Dave Barton used as the basis for his determination, that is good law. It has not been overturned in New York. You know, the cases the applicant provided to us did not really, it didn't change that underlying principle that the zoning officer used as the basis for his determination. So what I found was a 2018 case involving the city of Saratoga Springs, which had similar facts to our situation, where someone wanted to do a driveway through a zoning district in order to gain access to another portion of their property that was in a different zoning district. And again, the driveway was prohibited in the zoning district that provided access to the road. In that case, the ZBA decided that a use variance in order to gain access to the back portion of the property by a driveway, the use variance for that driveway was not required. And the appellate division, third department, upheld the ZBA's determination, finding that it did have that authority to modify or to, you know, basically determine that a use variance was not required for that driveway. So a similar set of facts, and basically very strong language from the court about the authority of the ZBA to basically make a different determination or modify it, to make a different determination than the law, basically. And so after discussions with the chair, what we drafted for the board's consideration is a resolution that is focused on, again, the uniqueness of the situation that we're dealing with here, the unique facts, and that would not, in my opinion, set a precedent for the town. You know, it would be limited to the specific facts that we're dealing with here, where we're talking about a driveway through light industrial to gain access to residential property split zone. The bulk of the property is residential, and it's landlocked, and the driveway would have minimal impact on the light industrial area. So that is, based on conversations with the chair, the resolution that we prepared for the board's consideration. It would uphold the zoning officer's determination, because again, that's based on sound law, and that is, and will continue to be the law in the town of Lloyd. It would reject the applicant's appeal, and it would, on its own initiative, modify the interpretation done by the zoning officer to allow the surgical exception to the general principle of law. So if that is, if the board is comfortable with that, that is the resolution that we drafted, and I'll turn it back over to you.
Can you speak a bit to the use in the light industrial? The split use for the light industrial and residential?
Right, and this is something that I've confirmed with our zoning officer. Basically, we're making this portion of the applicant's lands, we're using it for residential use. If you approve this resolution, and based on the zoning code, that's their option. They either use it for light industrial or for residential. They're choosing to use it for residential. It will be residential, and no light industrial use of those lands would be allowed.
Does any board member have anything to add? Mr. Gilchrist, do you have anything to add or questions?
No, sir, I don't have any questions. I appreciate Mr. Van Cott's review of the proposed resolution. I think one procedural point, just to make sure it's clear on the record, that in the event the appeal is denied, this is still, Paul, if you will, within the context of a zoning code interpretation, so that there's no secret determination that's required. And in the event this resolution is approved, that would then render the use variance application moot. Do I read you correctly?
Procedurally, you're exactly in the same place. Yep.
Thank you. No further questions.
All right, thank you. All right, so I think at this point, we'd like to have the resolution read into the record. And then I would entertain a motion to approve. Thank you.
Paul, if you could just pull the mic a little closer to you.
Sure can. Yep.
Sorry.
This is a resolution denying the appeal from the zoning conformance determination by ADC Ulster dated January 13th, 2022. Whereas on July 20th, 2021, ADC Ulster appealed to the town of Lloyd Zoning Board of Appeals for reversal of a June 21st, 2021 zoning determination, the determination made by the Town of Lloyd Building Department Director with respect to the applicant's property. Property tax parcels SBL numbers 80.3-1-18.1 and 80.3-1-3.1 located on Upper North Road in the Town of Lloyd, Ulster County, New York, the site. Whereas the site is primarily comprised of lands classified single-family residence, 1 acre, R1, by the Town of Lloyd zoning code. However, a small portion of the site along Upper North Road is classified by the zoning code as light industrial, specifically 483.20 plus or minus acres of the site are classified R1, while 36.5 plus or minus acres of the site are classified light industrial. Whereas the light industrial portion of the site includes the only lands on the site that are accessible from a public road, necessitating a driveway or road for any use of the vast majority of the lands on the R1 portion of the site, which requires vehicle access. Whereas the applicant proposes to undertake a residential subdivision on the R1 portion of the site and to provide 2 access roads to the development from Upper North Road through the light industrial portion of the site. The applicant had originally proposed to also locate a private sewage treatment plant on the light industrial portion of the site, but has since modified its proposal to relocate the plant onto the residential lands. And whereas the determination found that since residential uses are prohibited in the light industrial zoning district by the zoning code, the proposed roads and treatment plant intended to serve the residential subdivision are also prohibited. Whereas the applicant in separate submissions dated July 20th, 21, September 20th, 2021, and December 8th, 2021, collectively appealed from the determination pursuant to the zoning code and asked the ZBA to overturn or vacate the determination. And whereas the ZBA's decision on the applicant's appeal is a type 2 action pursuant to the New York State Environmental Quality Review Act and its implementing regulations in 6 NYCRR Part 617, collectively secret, specifically 6 NYCR Section 617.5 C16, so no additional seeker review is required. And whereas the ZBA has reviewed the determination, the appeal, and legal guidance provided by its counsel, and whereas the ZBA has opened a public hearing on the applicant's appeal of the determination on October 14th, 2021, and closed it on January 13th, 2022, after hearing from the applicant and providing the public with an opportunity to be heard. And whereas the ZBA has the authority under zoning code section 100-56 and New York State Town Law 267B and New York case law to grant, deny, and or modify the determination. Now therefore, be it resolved that the applicant's appeal is denied and the determination is upheld, except that the determination is modified to allow the 2 proposed access roads for a residential subdivision from Upper North Road through the light industrial portion of the site, based on the following findings by the ZBA. 1, the site is split by the zoning code into 2 zoning districts, light industrial and residential 1, with the vast majority of the lands involved in the R1 zoning district. 2, access to the site from a public road may only be obtained through the light industrial portion of the site, and there are no alternatives for vehicular access for uses on the R1 portion of the site that do not require access to the light industrial lands. 3, the proposed roads through the light industrial portion of the site for residential subdivision to be located entirely on the R1 lands will not have any impact upon or change the character of the light industrial zoning district. And 4, the literal interpretation of the determination to the proposed roads would prevent the majority of the site from being developed for any of the residential uses allowed by the zoning code in the R1 zoning district. And 5, the combination of these circumstances is unique to the site, and there is no other parcel in the town of Lloyd where residential uses on the majority of the lands involved would be precluded based on the strict application of the determination. And 6, modifying the determination to allow the 2 proposed roads for the residential subdivision through the LI portion of the site is justified under these unique circumstances in order to avoid unnecessary hardship or practical difficulties arising from a literal application of the determination in this specific case. And be it further resolved that this modification of the determination is unique and specific to the site based on the facts and for the reasons set forth herein, and shall not be construed to create any precedent in other circumstances involving any future application of the determination, which shall remain a binding interpretation of the zoning code, absent its rescission or modification, amendment of the zoning code, or a court determination. And be it further resolved that accordingly, no use variance is required for the 2 proposed access roads through the light industrial portion of the site for the residential subdivision on the residential portion of the site. Be it further resolved that this resolution shall be filed with the town of Lloyd town clerk within 5 days of its adoption, and a copy sent to the applicant. And be it finally resolved that this resolution shall become effective immediately upon its adoption. Mr. Chair.
Thank you, Paul. Any member of the board has any comments, concerns, or questions on the resolution as proposed? All right, I'd like to entertain a motion. Russ, Bill? All right. It's an aye for me. Over to with absent. Bill Brown?
Yes.
Russ?
Yes.
Sean?
Yes.
And Jessica.
Yes. Okay, we'll rate you in.
Thank you.
All right. Resolution. passes. All right, thank you, Mr. Gopers.
Thank you very much, board, for taking the time to review this matter. We appreciate it.
All right. So, second item is.
Right, so I don't think you need to formally close the public hearing on the use variance. I think that's.
I think it just becomes moot, right? It just,
Yep.
so the second item is moot from the determination of the first. Okay. All right, extend public hearing, 180 South Street, LLC, 180 South Street, 87.3-5-14, commercial area variance. Applicant seeking an area variance for side yard setback, full yard setback, and minimum parking. All right. How you doing?
Doing good, Chair. Good evening. Members of the board, how are you?
Good.
Good to see you again this evening. Again, my name is Brian Sipperly with Beverly Engineering DPC. We represent the applicant, DJ Direct Incorporated, for the proposed project at 180 South Street. The board has seen us a couple of times in the past. Once being at the August 2021 meeting where we had a kickoff discussion about the application. The second meeting was December 9th meeting, just prior to the holidays, where we continued that discussion, opened up a public hearing, and we had some comments and questions that they wanted the applicant to address, and that meeting was adjourned. So we are back in front of you this evening to continue that process. At this point, I'll ask you a question, Chair. Do you want to pick up where we left off, or do you want me to kind of step back a little bit? Forwards?
We reviewed your answer, on all of the points. By going over this, I think we're missing a few things here. You need a building coverage variance, a lot coverage variance, which I don't see here that you've applied for. And also, there's a stipulation. Hey, can you bring up the part of the code?
Oh.
With the non-conforming uses with the 50%
Okay.
building coverage. So in this part of the code for the non-conforming uses for structures, you actually trip the threshold for needing an additional variance. Because your coverage, as you can see, 100-17. Your coverage in the code, it allows for structures altered to an extent greater than 50% is determined by a code enforcement officer, and your coverage is more than 50%. So that would trip the need for. When I say more than 50%, so what you had originally, that building, you're allowed to go 50% more than that building, which you had previous, not 50% complete lot coverage. This is 50% of the structure when the zoning was enacted. Yeah.
So 50, we, if the current owner took title at 87,000 and change, that applicant cannot make the building 50% larger.
Not in that. No, it reverts all the way back to 1974 when the zoning was enacted. So in 1974, it was around, I'm going to say 25,000 square feet. So once you get beyond that 50%, it trips another variance. You would need another variance. I just want to make you aware of where this is going.
So ultimately, the board has prior applications and variances to how it got above 50% to 87,600.
I would have to ask Dave.
I don't think we do.
But we're going to be subject to that because no previous applications or resolutions were applied. I'm trying to follow you where it's going.
Well, just on what you've submitted, right? So pre-1974, your building, I mean, if you want to come up here and take a look, your building was here, right?
This is what we gave you, correct?
Yeah, this is box. The one in green is what you had. So over the years, it's expanded.
Correct.
To go over that, and you want to go beyond that again. So you're allowed 8%, you want to get up to 41%,
Correct.
right, for building coverage. I'm not talking lot coverage rate, I'm just talking building coverage.
Yes.
So I'm just pointing out that I think you're gonna trip another threshold.
Okay.
To where you would need one more variance.
And that is because 87.5 to the 113 or so is a 50% increase?
No.
Okay, I get where you're going, and I appreciate the board looking at this in more detail. I'm just trying to take notes as well, so I'll let you continue on.
Okay, and that's why I brought it to you, no, because we're working through this, it's a work in progress, so. All right, so in your answer, I saw you gave us a map of the existing loading docks removing them, I believe there's 15,
Correct, or 15 present voting ballots.
right? And you want to consolidate that, make 5 loading docks all in one area.
Into one loading area.
Right, but by doing that, and this is my feeling, I think you're gonna be too close to the property line, and I think it's gonna be very hard for trucks to transverse that without going on to, the neighboring property. Okay, your turning radiuses, I think I asked the last time for the, where you came up with the data for turning radiuses.
Were we talking specifically about around the building on the, let's say, southeast corner, or were we talking on the CR 20?
No, we discussed it, but it's where they're coming around the building. I saw you modified where you go out onto the highway.
Yes.
This area right here, where you come around, where you propose the 5 loading dock
Yes.
area, this area right here,
Southeast corner, yeah. Yep.
right? What did you use for the turning radius here?
It is not labeled on the plan. It was a balance at this point. As you can imagine, we are not in planning, we're not in full design, right? The balance is always, how am I going to deal with additional impervious area on the site, down to the low area? How do we minimize that on a lot coverage site? We can, we have some constraints. We have a fence and a propane tank that we would not like to shift any further. I do want to point out to this board that these turning templates that are built into these programs that we use, that is the largest truck, WB 67, 53, excuse me, 50-foot long trailer. They, in actuality, do better than what we show. We tend not to over-engineer and provide the impervious to do that. So if the pavement shows that we can make the turning radius, the trucks can use the turning radius, not experience. If a truck needs a 50-foot turning radius and we throw it on and there's a lot of empty pavement still left, we generally we'll trim that up as necessary. But I hear your concern, and I believe that if the applicant is allowed to move on to the planning stage where things like stormwater impervious and how we're going to deal with that, if we can't get that to happen, then I think the applicant would be faced with having to drop the dock. But having the variance will only allow them to do it if we're allowed to go to the next step. The variance that is to the side lot line because of the extra dock.
Right. Okay, so Paul, can we discuss building coverage now, or he has to apply?
I think it is essentially the same dimensional variance. It's a different language to talk about the same issue. I think you're fine to discuss it now.
Okay.
You know, because you're still looking at or thinking about the standards from the same standpoint of trying to minimize what are the impacts, was it self-created, that sort of thing.
Right. So does any other board member want to discuss or have any questions, concerns, comments on the side yard setback? It's required 35, and they have 26, 7.
That's not unreasonable. That's one of our testing points is, you know.
It is. I think it is unreasonable.
Consider that excessive?
I do, because in a typical application, it wouldn't be. But what I think we have to consider is what they plan on doing in that area. So in that 35 feet, that gives them more room for access, more room for trucks, more room for everything. So we're reducing that down to 30 feet, 2 inches, and 26 feet, 7 inches. 20,
Okay, you're gonna count.
Is that point, or I can't see from here, and I can't see over here either.
26.7.
Yeah, 26.7.
Is it 30.2 feet or 30 feet 2 inches? I can't see it.
This is 26.7 right here, and 30.2.
Okay, so it's 30, so it's actually not 30 feet 2 inches, it's 30.2 feet, 2 feet. Okay. So I think that does bear on our determination. Because if there were more room there, I think it's easier, it's better. So that's just my feeling.
Adjacent to that area, that the entrance is it a residential? What's on the other side?
It's in an ag zone, but it's not their property. It's, they don't,
Right.
I believe,
I can show you actually if you'd like.
I know their septic system is over there.
Septic system's here.
Right.
This is the building now. There's a house here.
Right, but ultimately, regardless of the use, I don't think they can get trucks past their building without going on somebody else's property. And if we can avoid that by not granting the variance, I think we're.
No, unless and I don't mean to intrude, but unless obviously we all know that the projection for the visual and the property lines are off.
Right.
Like, because they're mapped in different projections. So I'm not sure what this is going on here. If this is,
That's a concrete pad.
I know,
They actually
but that's
show
got to
it.
be on the other property, isn't
It
it?
is, right, and you show that in one of your maps, that it is on the other property.
It is, right?
The concrete pad.
It is, so Mr. Barton is correct in that I think we talked about this at the summer meeting, just how planimetrically aerial photography is shot at an angle from the satellite and the property lines are kind of laid into B. This image does not show an encroachment, but the boundary survey showed a slight few feet encroachment of that concrete pad did extend on, and that would be removed as part of this plan, and that encroachment would be removed.
Right.
If I can, I do resonate with your comments, and I don't want to minimize them. I would like to see if the board could guide whether this variance being requested and how we can test it against the five, tendencies of the law and allow space and planning and circulation to be a planning department issue. If we could let the planning department look over that kind of stuff.
Certainly, we're going to consider it, this board will consider it as well, not perhaps to the extent that the planning board will. But I don't think this board is going to, okay, now let's talk coverages a little bit.
One more thing on that area variance side, Chair, is by virtue of the board granting the variance, albeit concerns you have about circulation and movement. If the planning board felt strongly, just because this board granted a variance doesn't mean that we can put it there in a planning we are allowed to move on as well. We just wanted to point out that just if you do have a concern.
We're very well aware that if we say you can do it, that doesn't automatically grant you do it. We're very well aware.
And I just wanted to point out as we go through, the variance in specific to the side yard setback is not substantial. Because of the neighboring use and what is there, in its proximity to the floodplain, nothing's generally going to be built in that area. We are taking trucks that are pointing headlights in that direction, so if somebody was to put anything and use their lot in the back, they're subject to headlights and truck, the tractors of the truck are actually idling on the concrete pad, which is why I was there. We're trying to, in fact, improve the character of the site. We can go through some of those criteria, each one if we can. But I just wanted to point out that that's kind of what our position is on that variance. Thank you.
Okay, so on coverage, Okay, so coverage right now is not in front of us, but it will be. As it stands, building coverage, they're allowed 8%. As it stands right now, they're at 30.69%. And what they are requesting is 41.51%. So that's significant. That's a lot. If you're allowed 8 and you're looking for 41.5. It's a lot. The reason it,
Yeah, I'm sorry. I just have a quick question. I spoke to Andy Learn. I just have a quick question. The area here in section D on the map, up on the screen, is that part of the calculation for existing coverage? Yeah, that open area in the back, you remember?
when you say coverage, you mean lot coverage or?
Lot
building
coverage.
Lot coverage.
So we keep the questions about existing lot coverage.
Yeah,
Is that area?
counted in your existing conditions for coverage.
No, that area now is not a building, but it is impervious and it is reflected as,
As part of the lot, as part of your pavement, so it is.
correct, so in the
Right, I
existing
got you.
condition,
Okay.
right, in the existing condition, that is
Pavement
a
area.
lot coverage because it was all gravel.
Right, okay, that was important because you guys, if that got added in, it would change the dynamic of what you would have to consider for relief, but if it's already built in, then your lot coverage.
And that's not for building, that's for lot.
For lot.
Does this board view the legality of the request from 8% to 40? Is there any, were there any variances granted by previous owners to get to the 30%? And that be deemed an existing condition?
I do not know if any variances are granted.
Okay.
We could probably research that.
I wasn't sure whether we were coming at an increase of 30% to 40% versus the 8 to the 40. Well, we aren't really going from 8 to 40, right? We're taking the existing conditions.
No one thinks you're going from 8 to 40. You already know you're at 30 and you want to go to 41. 8 is allowed.
I agree. How we got to 30, I don't even know, right? And that's even grossly over the 8. I agree.
Right, and now you want to make it even more.
If the applicant would like to, unfortunately, it does sound like we're making it more.
Well, it doesn't sound like it. You're absolutely.
Well, what they're doing to the building and the undertaking, is really trying to fix an asset, and unfortunately with that, they'd like to increase it in areas, I'd like to point out, in areas that won't be seen from the street. They're buffered from what the uses are, but yes, we are absolutely
Okay.
asking to go.
Let's dive into that a bit. Dave, can you bring the map kind of more, the building more into the center of the,
I agree.
I'm gonna stand up, it's just easier. How's this?
Oh, look at you.
All right.
Look at you.
So this area right now is a parking, right? This is a parking area, does not have building coverage, it's a parking area.
No, that area right now is all paved. It's multi-tiered where it's ramped up and you can get to.
But it's not a building.
No, it's paved. It's an incomplete paved area.
It's paved, but it's not a building, so it doesn't reflect in building coverage. It's building coverage, lot coverage, so this area right here is parking right now.
I wouldn't call it parking, it's loading. As far as the cars are occasionally parked, there's no striped areas, I believe. Out along South Street there are. I have any conditions. It was part of the
Yeah,
the applicant, we can bring that up on screen. The application.
Existing, can you bring up the existing condition, Matt?
you can look at it here, John.
Okay.
Yes.
Right, so this right here, if I'm not mistaken, there's parking here, there's parking here. But this is not, this area right here is not a building, and you want to make it a building.
That area is a concrete apron that your pen is closest to.
Mhm.
Further to the west is the asphalt. There really are no striped spaces per se there. If people are parking, it's because you got an employee who kind of pulls right in, but that's a loading area. that you're pointing at. If I may,
Okay.
just jump behind you here. So this is an
Dave, can you-
this is at grade. So
Mhm.
so on this concrete apron, dock doors are at grade, you can drive in, zero threshold, if you will. This area here is sunken in relief and that is a dock elevation height. So trucks actually pull it
Dave,
down.
can you bring up what they have provided us for the loading docks?
Oh, yeah. Sure, now you're gonna make me have to go find it, huh?
Sorry, Mike.
Give me a few seconds.
So you're looking for a picture chair? The picture of the loading dock that we saw?
No, the key.
The key map.
Okay, so bring it up. So right here on your key, which you submitted, you put it as a parking area.
Point of clarification for you all. That exhibit came from the applicant. I don't know where they got that site plan.
Well, I know where I got it. I got it from you.
I know, I see where, I have to, this was an exhibit I built. This was meant to be a key map. This was not meant to be a site plan alternative to what is on record here. And I do apologize for the confusion.
But what you just showed, that's not on record. That's proposed.
Well, this is what's on record. That was submitted, it's called a key map for building, right?
Right.
So I just, again, I see where the confusion's coming when you're talking parking. This exhibit came from something that the applicant got through a change of title, right? This is, I remember seeing this drawing from when the applicant called our firm. That is not parking today. Like, if they show that to somebody, if they thought of that over time, I didn't think of looking at this site plan chair and saying, oh geez, I gotta go into your CAD file and edit out a bunch of things that are confused the chair. If you may, if you can, literally use this exhibit only for the red dots to show doors. Everything else, unfortunately, that is not a different, if we drive to the site tomorrow, there are not striped spaces there.
Okay, that used to be a parking area.
If it
When it was
was.
Plasmaco, when it was Panasonic, that was a parking area.
What I can tell you is.
It might not be now, it might not be striped, but my point is, right now, it's not a building.
Agreed.
So, for coverage, and this is me, the rest of them, I'm not speaking for the rest of the board. I would be more comfortable as this being extended into a building and not this, because this, you can't see. There's a buffer, there's a natural buffer here, there's a stream, there's a wetland. Even if they develop where the apple orchard is behind it, you're not gonna see the back of the building because there is a natural buffer, a wetlands, a buffer right there. I'd be more comfortable with this as a building and not this, because if you make this straight across like this, it's gonna look like a huge block as you're driving down the road. At least this has a little character to it, and you could clean it up, you could take the docks out or whatever you want. But if we can get a calculation of, and if the applicant is willing to remove that from the proposed building and see where that puts you for lot coverage.
Building coverage.
Building coverage. Thanks, Dave.
I wish I had it still with me to tell you right now, but I wouldn't. But duly noted, we can come back with that.
And you may come back with it, and this is also where, this was the plan that I was looking for here that we didn't have. That's where the concrete is extended onto the neighbor, which you're gonna remove. If you go with the.
Whether we are allowed the variance for 5 docks as part of the construction of 4 or 5 docks, the removal of the encroachment would just occur along with the right. Sure. As is, I don't think there's an entitlement to let it be there, so.
Yeah, speaking of entitlements, I thank you for the submission of the effluent discharge. It satisfied me. I don't know about the rest of the board, whether you guys got a chance to look it over. Paul, did you get a chance to look it over? It seems satisfactory, correct?
The recommendations.
Okay. Any board member has any questions, comments, concerns? All right, this time I'd like to ask any member of the public if they have comments, questions, concerns. All right. So I think what needs to happen at this point, we need to keep the public hearing open. We need to figure out exactly what variances need to be applied for. Definitely the side yard, definitely the total side yard. Building coverage, lot coverage, because you're changing both. I think they both need to be applied for. Oh, parking. And that brings me to my next point. If the applicant amends their building footprint and actually strikes what we were just looking at, you'd exceed the required parking. So that may go away.
I would agree that that would provide areas to make up the remaining spaces that would.
Right, and I believe you have enough to reconfigure some parking on the, where you have for loading docks, or it gives you a little more flexibility and leeway. But I believe if the applicant, is willing to change the footprint of the building and make that, or let it remain as parking, it's already an impervious, surface. I think the parking issue goes away. The other, variance that I think we may need, and this could be between the applicant's council and our council to determine whether they did trip the 50% threshold. The applicant brought up valid points on how we determine that. So if we can go over that. Do you have any questions for the board? Do you have any?
No, I think I would hope to, I guess, just pulse the board in terms of, the 5 items we had. I think that we adequately addressed at this meeting some of those items, or are there any open items that we failed to update you on this evening? And I'll just remind the board of what those general 5 items were. Sanitary easement was a concern of the board last time.
We did.
We talked about the 3 variances in the application needing to be 5. Those 4th and 5th were lot and building respectively, and Aggie Mountain, we're talking about another one. Truck volumes, we discussed elimination of a loading dock, building addition history, and application trying to put together that with his records, and just demonstrating to the board that the concern of trucks extending on to southbound lane of CR 22 can be adjusted planimetrically. We do have the space. And so those were the main topics that we left at the adjournment last time. So I was just asking the board to make sure that they were satisfied with what we had brought back for those items, and then writing down the new items that we have in front of us.
Right, and they're dead set on the 5th dock, huh?
They are in that, because they're, there was a video I didn't send you guys. I don't know if you saw one of the photos of the trucks jackknifing into the front. I mean, they use the facility, unfortunately, the way they took title, and it's not efficient, and it's not safe. And because of, I think another member of the public indicated, right, because of the different finished floors and where things have to come in and how it comes in, a container ship from China that's floor loaded has to go to a dock that can kind of be stationary, right? It doesn't move, takes 2 or 3 days to unload and palletize. So they use everything in concert, but it also depends on the movement, right? So I can't put it at this dock, it's meant to put a forklift around the outside, as they mentioned, and they're trying to rid that, right? So because of the 5 docks, we did ask the applicant to come back with their concrete evidence of building operation. And, what they deem is necessary to be 5 docks, because of what they've described to me, and what I put in the application, is that generally 2 docks of the 5 are stationary. One is generally only 2 to 3 a week max, and that's for the containers that stay there and get unloaded. The other one's generally a stationary UPS truck that come in and out twice a day, so kind of dock up and load and come back again. And then the other 3 would be used for, some ins and outs. And then we're trying to consolidate that in one area as well.
When you're up, Dave, can you bring the building more into focus?
Oops, sorry.
So,
All right.
are you right with me again?
Oh, there you go. Loving it, John.
So, and this is on you. Sure. Just a suggestion. You take this dock off, and you put it in over here someplace, so the truck will come in like this, back up. You'd eliminate the need for a variance, both two variances. And what you just said is you have a stationary truck that needs to be hand unloaded or whatever the case may be. If that's in this area, you don't have forklift traffic going around, guys working. It may be beneficial for you to kind of look at putting one of the docks right here. Is it eliminate the variances or get that off your plate completely? And I think it would be better for your truck flow because you're not gonna have, if you have a truck sitting right here, these trucks are gonna fight to get in. So the truck that sits stationary could be completely on its own over here. Just a suggestion, I mean.
Yeah, duly noted. My wheels are turning. Take that into consideration.
All right. See that, you may have just eliminated two of the variances. All right. Any board member have any questions, concerns, comments? No, it's fine, gentlemen. Everybody's good? All right. Entertain a motion to leave the public hearing open. Do I have to entertain the motion? Or can you get to leave the public hearing open until this one? Aye. Okay.
Thank you, Chair, members. Good evening. Thank you again for continuing the review of our application. Okay, so what happened? No use variance left? What's that? You upheld the determination?
Because
They
I'm
didn't
awesome.
need a use variance so the road can go? The last case, I was trying to follow it.
It's complicated.
It is
I know,
complicated.
but in the end, I was reading
It is
I was looking,
complicated.
It's why we hire attorneys.
So the road can go in, that was my eye opener, I thought, interesting, okay. And I think you caught the attorney off guard when he said, so the next thing will be moved, I don't need to apply. Thank you, I just wanted to make sure I heard that correctly.
Like to keep
But
everything.
listen, last time we had to listen for a couple hours, right? Thank you all.
Have a good evening.
Thank you.
Okay, new public hearing. Pino Foods, 304 Station Road, STL 86.4-1-22, commercial area variance. Applicant seeking an area variance for a max lot coverage of 10% to actual coverage of 35.3%, 5.9% increase from previously approved site plan. Determination that 100-15B11 50-foot buffer setback is adequate to permit the amendment of the applicant's site plan originally approved on 3/21/02 to delete the 12 parking spaces on the north side of the building and add 17 parking spaces on the east side of the building.
Good evening,
How are you, sir?
my name is Phil Gambitone, the office here for the applicant. And at our last meeting in December, he left me with 3 items of homework. One was to verify the septic system because there was some confusion on my part. I represented that the septic system was on the west side of the driveway. And that stemmed from a site visit with the owner and the engineer, where the owner represented that his recollection back in 2002, when the septic system was installed, it was installed to the west of that driveway. Subsequent to that meeting, and unbeknownst to me, the engineer pulled the application from the Ulster County Department of Health for the design system, and it was shown designed to be placed to the east side of that driveway. Both the owner and the engineer have reached out to Lee Boyce, who was the engineer of record at the time, to see if he had an as-built so we could determine where, resolve the owner's recollection versus the original design.
You don't know where it is.
With that,
You don't know where it is.
as of today, we don't know. So what we're doing is, the engineers enlisted, are trying to enlist a, company to come in where they put a stake down the line with a sensor on it to physically locate it, but we were unable to complete that task before tonight's meeting. So that's still an open issue. Okay. The second item for homework, you requested copies of all the deeds for the parcel in question where that new parking lot is. Due to some COVID problems and the holidays, the title company was unable to get me all the copies that I needed in order to prepare a memorandum for you on time. So we'll have that for you at the next meeting as well. And the third item of homework, it was requested whether or not we could have a 10-foot buffer between the edge of the pavement and the property line. because as of now, it's about 5 feet. So the engineer looked at that. We need a 26-foot fire aisle next to the building and an 18-foot parking space, and we have roughly 55 to 56 feet, so we could accommodate the 10-foot buffer area between the property line and the edge of the
Shoot those numbers back at me. The fire lane, the parking, just coming with.
There's an 18-foot parking space and a 26-foot fire lane. Basically, the lane down the.
Okay, so. So from the edge of the building to the edge of the parcel in question right now is 55 feet.
Well,
Give or take 55 to 61.
Right.
Go by memory. I don't
if
see
you
it.
pull up the original site plan,
Why would I want to do that? That
this
one?
here, you'll see that the building varies from 5 to 6 feet from property line originally.
Right.
And then that parcel is 50 feet wide.
Right. So like
So we have roughly 55, 56 feet to work with.
55, 56, and you need 44.
Correct.
Again, just have a hard time looking at this. And you had an approved site plan and you just didn't do it. And I know we went over it.
We went over it.
You said the owner didn't know, but the owner signed the approved site plan.
Yes. I will point out that this site plan complies with section 100-29D2, where all off-street parking should be located behind or on the side of the principal building. And it also complies with 100-29A, where it talks about the purpose of the off-street parking provisions are to keep off-street parking areas. They should complement the site, improve the appearance, protect the character of the residential district, and to minimize visibility from public roads. So by putting the parking here, it's shielded by the natural landscaping on the front, because there's trees there on the shown below where the septic is. That's all treed there, so it shields the parking from the road, whereas moving it back to the road side of the building would conflict with the existing zoning guidelines that don't want parking on the road side of the building. They want it on the side or the rear. You had indicated that you may go out and do a site visit. Did you have an opportunity?
I drove by, did not pull in.
I still invite you to go see
I
it.
didn't see anyone there. I think I went on a Sunday. Okay, I didn't want to drive on somebody's property that.
We invite you to come out to the site and review it for your own purposes. We can arrange, I can arrange to meet you there. The owner can, arrange to meet you there, walk you around. I understand that it doesn't comply with what was originally applied for, but there was an issue with this particular parcel, the lost deed for this parcel that has since been resolved since 2001 when the property was purchased.
And we'll have that information.
We'll have all that information, yes.
Before I open up to the public.
And I also want to, there's a lot of discussion on lot coverage and stuff, and we are, a large portion of our lot coverage is that vacant or the slab there, because there used to be 2 coolers here.
When you did your original lot coverage, there's a parcel that used to be owned by someone else.
I used to be owned by David Moore's little square out front.
Right.
Yeah.
When you did the calculation for lot coverage, you added that to this lot?
What we did was we took the 4.6 acres, and then the engineer mapped out the parking areas for the foundation and the existing building, and then divided it by the 4.6 acres of this new consolidated lot.
That was my question.
Yeah.
This lot is now consolidated. That, the calculation was done with the Roars parcel included.
The Moore's parcel and this little,
And, right. Anybody have any questions for the applicant? Or we, time, let's entertain a motion to open public hearing. Bill? Aye. Good. All right, any member of the public wish to be heard? All right, Phil, can you just go back and let the public come up to that table? Thanks.
Oh, lovely.
Good evening. My name is Patty Brooks, and I'm here this evening not in favor of or in opposition to this particular application. There were just some comments and statements that were made at the last meeting that did involve me and the previous site plan that I prepared, so I thought it would be important to come here this evening and clarify some of the issues and correct some of the misstatements that were made.
Sure.
It was stated last month that the driveway and the parking on the east side of the building were in place in 2001 when the applicant purchased the property. And I contend that that is not the case. As shown on our original site plan, that was not paved. There was no driveway there.
I have it up, Patty. That map,
So,
I believe that the applicant presented last month, and I don't know that I have enough to hand out to everybody, presented last month a 2004 worth of digital map showing the location. I believe that Mr. Barton would be able to pull up the 2001 aerial view from the parcel viewer. And you'll see if you look at the 2001 aerial map, there was no parking lot there, there was no driveway there, and it was wooded. So I'd like to clarify that for the record.
thank you.
One of the statements made was that the surveyor didn't do their homework with regard to the ownership of the property. At the point in time that that property was surveyed in 2001, we surveyed the only property that was conveyed to Casino Foods. We did the proper deed research. At that point in time, the deed stated that it was bounded on the east by the Penn Central Railroad. It's not incumbent upon us when we're surveying a parcel of land to also survey all the adjoining parcels. It was very clearly defined where the easterly boundary was, and that's the boundary that we held.
In the narrative, it said, the railroad, it said Penn,
It did.
okay.
Subsequent to that, in 2018, when I was hired by the Zimmermans to survey their property, that is when I discovered that although they were being assessed the property, they didn't own it. And at that point in time, I made the Zimmermans aware of that. I believe that's when this issue originally came to light. The current deed of record, which is available readily from the county clerk, is a consolidation deed that was filed April 9th of 2021, which includes the original Millbury Bridge Company parcel that was conveyed in 2001, which is shown on our site plan map, together with the premises conveyed by Dave Roars and Judy Roars, which is that small front parcel, and together with the premises awarded to Pepe and Sarah Realty Corp. By judgment dated March 23rd, 2021. They had to file an Article 15 for that. The lost deed was never found, and this is a race state anyway, as Mr. Jambertone notes. So even if they did find the deed, the fact that it had never been filed with the county clerk, I never would have been able to find that anyway. I was hired after, I believe it was in June or July of 2001, after Joe Rones of Finkelstein and Partners had already received the use variance for the property. Of course, Millbridge were the ones who had to get the use variance because they were the ones who purchased the property. it wouldn't have made sense for Pepino Foods to apply for it because they would have then created their own hardship by purchasing the property. At that point in time, I had foiled the town to ask them for a complete file of the use variance so that I made sure I prepared the site plan correctly and accurately. And in the information that was supplied to me, there was a map, it's called Selected Site Features Map of 304 Station Road. I did not want to unstaple this because it's been stapled since 2001, but I can pass this around. At that point in time, it showed the two-story vacant warehouse, the gravel parking area on the westerly side, and they actually call it grass and wet area of standing water on the easterly side of the building.
Can we get a copy? Can we copy that?
Patty, that's up to their map.
Yeah, Patty, can we copy that?
Oh, of course. And it should be, I got this from the town records, so I'm assuming it's in the town records as well.
Thank you for doing one more time.
There was also a question on whether or not a variance should have been required at the point in time that I did the site plan regarding the building and lot coverage. Of course, our zoning codes have changed over the years, and I have a habit of copying the zoning code and putting it in the file at the point in time that I do the survey, so that if a question arises in the future, I'm able to address it. At the point in time that we did the site plan, the A zone had a maximum building coverage of all buildings of 10%, and there was no lot coverage requirement. If you calculate the building coverage of 10,875 square feet, and at the time, the lot was 152,895.6 square feet, it was only a 7% building coverage, and you met the criteria, so no area variance was required at that point in time. With regard to the septic system, and again, I apologize, I only brought 3 copies of this. But that's a copy of the approved septic system as designed by Lloyd and approved by the Ulster County Board of Health. I only copied a small portion of it for you. This is the overall plan, but that's the improvement. You will also see that there is no driveway or gravel area shown there. The Board of Health approved this map. If there were a gravel driveway or roadway or anything else, it would have had to have been shown on here because the septic tank was supposed to be put right outside the northeast corner of the building. And then the laterals were on the other side of where the driveway now is. So there has to be some kind of piping crossing that to the distribution box.
Hey, can you bring up the proposed map? All right, thank you, Pat.
One more thing, although I didn't know if you, I was waiting for you. One of the other items that was stated is that Patty Brooks is rarely accompanied by clients and that the owner did not participate in the site plan process. I take great exception to that. It is true that I'm rarely accompanied by my clients because I seek counsel with them before and after the meetings. They're always involved in the process, and I do take exception to the allegation that he wasn't. Our firm in the 70s were the first ones, before any planning board required it, to have an owner certification on a map. We did that to protect ourselves, to protect the client, to protect the planning board. I clearly went over this map with Mr. Patella at the time. He signed it, saying that he reviewed it, was familiar with the content, and agreed to everything on here. And that's it. Thank you.
Okay, fair.
Mr. Chair. Someone else wants to speak.
Good evening.
Good evening, Scott Anselm. I'm a adjoining property owner to this location. Here with information as far as our lot, as well as my parents who own the largest portion of the farm in question. I just do want to point out part of the information that Patty just provided to you. Lou Du Bois not only submitted the septic application as a certified engineer, he was also the chair of the zoning board at the time. So I highly doubt that information would have been put on the map or approved by him if it wasn't part of the information he provided. As well as Patty, I mean, Patty covered a lot of the information I would have done. In less than 25 minutes, I was able to find on the county website all the information for the title and chain of title, going back to 1969 when it was purchased by Billy Palladino from Lindell Cold Storage, going all the way down through Hudson Valley Apple Products to Cornwell, to the companies that Mr. Young stated that they weren't able to locate, which is BBM with Milton, which is also Brooklyn Bottling. I'm sure everyone is aware that they're still in business in the same location. The property in question, if you do look, Dave, are you able to bring up the street view on Google Maps of the location? I'm sorry. It will help to get a little perspective.
I can give you
That's
that.
great, because actually I was gonna hand out maps of
I want
that.
to move it around.
We're right alongside of it.
Where your hand is.
If you stop by and see your.
Come on, guy, you know
So
something.
our farm is, we encompass total, myself as well as my parents, we encompass almost 60 acres there. We are a continuously operated farm. Actually, it's March 6th of this year, it'll be 100 years that our family has owned the farm.
Oh,
I have deeds that go back on our end, they go back to 1855 when it has continuously been farmed. I have maps that show from the New York Penn Railroad that actually in 1916, everything around it is considered a farm. There's orchards, vineyards. When we purchased the farm in 1922, it was currants and grapes. We've now progressed into apples since the 1950s. It's been a farm the entire time. I know Mr. Younghound pointed out that we did push out the acres that is alongside of it. It's 1 acre out of the 5.5 acres that is there. 1 acre out of the 60 acres that we have. As the chair pointed out, the costs change. So we did that because if you don't spray everything, a disease can spread to everything. So when you have something that's old, when you have something that's outdated, when you have something that doesn't make money, it doesn't make sense to continue to spray everything in order to keep everything healthy. So a lot of farmers do this, and a lot of farmers don't replant the following year because you don't know the next market, what's going to be viable. You also don't want to do it right away because you want to allow the land time to settle. And that's why things have not been done. But again, I did also reach out to Jeff Keogh, who is the ag protection planner for New York State agricultural markets. He did also point out to me and make me aware that the onus isn't on me, the farmer, to make sure that every acre of my viable land is farmed. We're not required to do that. As long as we are in a certified agricultural district, which the town of Lloyd has to apply to the county to be, sorry, to the master law. We have to apply to the county in order to be included in the district. The county legislature has to vote on the district and approve it. That district plan then has to be sent to the state and certified by the state. So in that, our protection is an agricultural district protection. We are included in that map. The agricultural market laws actually supersede town laws, which I didn't know that because we are in a protected district. I did point out and bring up the information as far as the town code to Jeff Keogh, and he actually was quite surprised. He was surprised in the aspect that the town does have the buffer requirement, which they do push local zoning to allow. I did also speak with Dennis Doyle at the county planning board level. He stated that when a lot of the information was coming out in the early 2000s, the town was very receptive in accepting buffers. And he actually was quite impressed that the town actually stated in their code and zoning what they required and what they wanted, which was the general consensus of planning at the time, and not a lot of towns went as far as doing that. One of the things that they did point out, and state that makes it quite clear in our town zoning, I know Mr. Youngstown stated that he believes that the intent of the law was for new residential districts only. When I spoke with Jeff Keto at the state level, he did read the zoning and read the law while I'm speaking with him, and his opinion is that the new residential district subdivision or other non-farm use. It doesn't say non-farm residential use, non-farm business use. It clearly states any non-farm use in the district. We are the farm, they are the non-conforming use. We are the primary use, they are the non-conforming use. They also state that there was no clarification on what the buffer should include. Like it should include a parking lot, if it should include a shed or anything like that. He did state, if you read it, because I was kind of concerned and looking for guidance, he stated appropriate landscaping and or vegetative screening shall be established to maintain such a buffer. In that right there is the legislation, is the intent that the buffer should be vegetation, not parking lot, not anything else. It should be. He did point out that there is standing statute in New York State that farmers, again, shouldn't have the onus responsibility of making sure that there's a buffer on our end in order to protect ourselves from liability from other neighbors. It should be the non-conforming use in the district, which is the business and Pepino's not farm. I also want to point out that we still don't have actual maps or topography from Pepino's to show the elevation. Mr. Johnson has pointed out in previous meetings that they actually have excavated on that site 7 to 8 feet, which then Patty pointed out is and was wet and a natural buffer. So that natural buffer is no longer there at all. Going back to the area variance, when speaking with the county planning board, Dennis Doyle, we did go over what the area use requirement is, and going through all of them, from self-created hardships to changing the impact of the district and what allowing something like this and not holding the buffer, what that could use other farmers within the district, set a serious precedent. It again would change the characteristics of the district. Will it be substantial? Yes. Every criteria there has been met by that. Again, we went with Patty and we sat down in 2018, which Patty made us aware of all this information. Dave, I think you have for the file, February 2019, they were made aware. It wasn't until October of 2019 that I found the deed for the railroad, which was provided to us, and the actual information provided for the railroad. And that was done via a tax sale deed, which was tax sale 104. It wasn't a lost deed. That keeps getting stated, a lost deed. A lost deed, if anyone applies to anyone, someone thinks that they lost it. They have the deed and we can't find it. They can't find it because it was never filed. A deed isn't formalized and isn't memorialized as law or a transfer of title if it's not filed. What wound up happening is because the titles were transferred at the time of the filing of the deed and the tax parcels were created at that same time, when we were the last parcel in 1991 to transfer title of the railroad property, we were advised by the town of Lloyd, which is part of our property record here, and I will read that. This is a letter from Ulster County, Bert Winning, who was a senior tax map technician in 1991, letting us know that we had been the winning bidder of the railroad properties that we had purchased, and that we needed to let them know when we wanted to have the parcels included in our tax map. If not, the town would include them. There's also information from January of 1991 from MB Balmer, who was the tax assessor for the town of Lloyd at the time, which denotes in our property card that all of those parcels were turned over and put into the same tax map. Because
Let me stop you for just 1 second. When you say all those parcels.
yeah,
As the way I understood it, as Phil was saying in the last meeting, they split the rail property in half.
they
One
did.
adjoining property owner got, when you say all the parcels, is it?
Because we purchased more than one. So what's happening is from Herds Road until, I forget how far into Apple Green on the other side of Station Road was considered one parcel at the time for tax purposes when it was owned by Conrail.
It's 12.5 acres. It was a 12.5 acre parcel. As each adjoining side, you either could buy your side, and if you didn't choose to buy it, your neighbor on the other side could buy your side as well. So we have portions where you zoom in just a little bit, Dave, where the pond is. Actually, Russ, if you just go down where your hand is, right below a little bit further down, that we own both sides. So we were able to purchase both sides of that railroad.
That's my question. Did you purchase both sides?
We purchased both sides there, and we purchased our side on the other side of Fiftinos. We also purchased on the other side of Station Road, which is where Apple Green Golf Course is. So we had 3 separate parcels that we had purchased from the Ulster County. All of those parcels in that 12.5 acres, they didn't create new deeds or new tax parcels until the deed was filed. We were the last ones to do that. At the time, there was a divorce happening. There was 12 different parcels and deeds that needed to be filed. We were the last ones to do that. We were also, because we were the last, the erroneous deed that was never filed was added to our tax parcel, which is why since 1990, it's been on our tax parcel. We have been taxed for it. We have been paying on that. That's how that rolls onto the tax parcel and the tax deed. There also is, and was mentioned at the last meeting, of the railroad property. And I kept thinking and listening to him when Mr. Galpone said that the deed says except and exempting the railroad off of the deed. That is incorrect. The actual, I have our deeds here and I have all the information going all the way back to 1855, which I have them here, and you're more than welcome to look at all of them. The only parcel that has anything on it that states except and reserving the New England Railroad is the 28-acre parcel, which is below Pepino's, which doesn't even touch their lot. It has nothing to do with the lot or now our subsequent subdivision 2 years ago, anything to do with the bordering property of the railroad adjoining Pepino's. So yes, that is correct. It is in our deed, but it doesn't have anything to do with the parcel in question. It's a subsequent parcel that's below that. So I want to make sure that was clarified as well. And there's many information that was readily available through Ulster County. That was find it in 25 minutes. Again, after speaking with both New York State and the County Planning Board, I expressed to them my concern. My concern was, as a farm, we have been a farm for 100 years. My dad has lived there his entire life. He has farmed his entire life. His father farmed the entire time. He had lived here and moved here when he was 5. It's a family legacy. We've been, my dad grew up on the road. There were 4 houses and 7 farms. We are the last farm on this road. At this point, the reason why there are buffers, why there is agricultural protections, is because at this point, everyone points in. Now we're the nuisance in the neighborhood. How do you stop that? How do you protect that? Is with buffers. And that is the one thing that New York State actually stated that they were happy to see that in legislation in the town of Lloyd, and that they hope that it was allowed because it is plainly stated in the zoning, residential or non-farm use. And this is clearly not a farm use. There's much more information, I'm sure, and I'm hoping that the public hearing isn't closed, and I'm hoping the board members are able to do more research as far as looking at the actual property. Were you able to pull the street view?
What?
Sorry.
Not a street view, no. I'm not gonna go do them now.
What we'll do, the applicant has afforded us,
Yeah.
the opportunity to go actually
If
look
you
at
are,
the site.
if you are able to do that, and you are able to look, if you stand on Station Road and you're able to look straight ahead at the building, you'll see where the driveway is, and you'll see the corner of the building where it's purported to be, and the driveway is not as far as they purport it to be. You also, Patty, very plainly stated the information that's on the maps available. You can see, if you look, if you zoom in, Dave, and if you're able to go.
I'm not sure I can go.
Can you go to 2009?
What?
Here's the color map, sorry. It shows you a little bit easier.
Boy, you are some.
You can see them parking exactly where they're supposed to be. They parked there from 2004, and on the map, it's clearly there. Whatever was done was needed in order to get the CO and to be able to get their variance. The parking lot is there. That was prior and after, while they were still on the parcel in front. And if you go to 2009, you'll see that they're parking where they're supposed to be. 2013, even though they paved, they are still parking where the parking lot was supposed to be. If it's not viable and they weren't able to do it, they were doing it until 2013. It still is a viable option. They also purchased, which is not on their map, they also purchased another 8.5 acres, which goes around their property, which gives them other options on the other side yard that isn't abutting the farm. It gives them other options. So I just want to point those out. I hope that the board considers leaving the public hearing open and considering all the options that are on the table and making sure that all of our concerns are heard. Thank you.
Thank you. Is there any other member of the public that was to be heard? Okay.
We are in fact going to leave the public hearing open, because the applicant poses some information. Very informative. Does the board have any questions, comments, concerns?
I would like to visit the site. If you want me to make arrangements for you, I can, or you're free to come by. If you want me to make an arrangement, I can talk with Jessica to arrange a schedule for everyone to go, or how you want to do that.
Sure. If you can set something up, that would be good. It's better for me if it's on a weekend, if it's not too much inconvenience for your client.
I'm sure he can accommodate you.
Okay. And all that's proper, right? We can. Okay. Sure. So yeah, I'm available any weekend, you know, the sooner the better would probably be.
Okay.
So if you can reach out to Jessica, and Jessica, you can reach out to
Sarah.
Sarah.
The other Jessica.
So, like I said, we're gonna leave the public hearing open. I'll try and get out there this Saturday. And yeah. Okay. Yeah, well, if you can set something up for Saturday,
This Saturday, you want this Saturday?
that would be great for me.
All right, I'll
Everybody
call
else
it
is-
tomorrow and try to set that up,
Okay,
and I'll
yeah,
confirm with the office.
okay, and if you can't,
We'll do
you
it
know,
next
we're,
weekend.
yeah, that's fine. We good? All right. Thank you. All right, minutes to approve. We had spoken about adding that I made the applicant aware of my relationship with the neighboring property owner, if we can add that to the minutes. The rest of it, I was comfortable with. Did everybody else get an opportunity to read the last one? I'd like to entertain a motion to approve the minutes as altered to reflect my comments. Bill, all in favor? Aye. Okay. I'd like to entertain a motion to adjourn. Come on, guys, jump in. All in favor? All right, thank you very much. Thank you, members of the public.